Hello again, and welcome to the latest in a series of online video lessons intended to provide you important principles and helpful tips regarding the understanding and practice of argumentation. In this lesson, we're going to start digging into the dialectical perspective of argument by examining the anatomy of a dispute. In other words, if there's a controversy involving disagreeing parties, what is that controversy made up of, and what are the responsibilities of arguers to address the relevant issues? So in order to do this, we'll briefly review what's meant by the dialectical perspective, and then we'll talk about some important concepts that basically break down the way that any dispute ought to play out. So we'll discuss concepts such as presumption, burden of proof, issues, and cases. Okay, let's get started. The idea of argument perspectives that comes from Dr. Joseph Wenzel reminds us that there are a number of different ways that we can understand argumentation as a field. You can think about it through the metaphor of a house. Each window that you look through gives us a different understanding of what's on the inside of the house. Some issues are going to be examined more closely, others not quite as well, and still others won't be seen at all. For instance, the dialectical perspective is going to help us answer the question, has the argument been sufficiently explored? The logical perspective is going to help us answer the question, is the argument sound from a rational standpoint? And the rhetorical perspective is going to answer the question, are the recipients of the argument likely to be persuaded? So it's this first perspective, the dialectical perspective, that we're most interested in. The concept of dialectic is one that comes originally from the philosophy of ancient Greece. The notion is that of a procedural seeking of truth via examining differing points of view through discourse. Plato's Dialogues of Socrates is perhaps the best example of this. When you have folks involved in a conversation that take differing points of view using argument, questions, and answers, eventually what you get at is what is probably closest to the truth. Although sometimes we think about this in terms of a debate between opposing sides, this is actually more like a discussion than a debate. Because what ultimately the goal of the dialectical perspective is to enable those who are witnessing as well as participating in the argument an opportunity to come up with the best possible decision. So the dialectical perspective focuses on and enhances a candid, critical, and comprehensive examination of all positions relevant to the topic. The idea is to provide a procedure for judgment and decision making. The arguments ought to be presented and compared in such a way that all of the relevant issues are laid out so that the audience can make the best decision based on the available alternatives. All right, so what does this mean for how a dispute is put together? We need to go over some primary terms in order to understand the basic anatomy of a dispute. So we'll briefly talk about the following: claims and propositions, presumption, burden of proof, case and prima facie case, issues, and stock issues. Let's get started with the basics. A claim is a most basic element of any argument. Ancient Tutor defined a claim as an expressed opinion or a conclusion that the arguer wants accepted. This is the primary reason why anybody argues. Someone potentially disagrees with them and you want them to agree with you. So if this is a claim, a proposition is an overarching or main claim that serves as the principal claim of an extended argument. So while a claim can be a specific position that you want accepted on a very specific point, a proposition looks at a much bigger issue. And in order to support that proposition or to oppose that proposition, there need to be a number of different arguments dealing with a wide variety of different issues in order to ultimately decide in favor of or opposed to the proposition. So let's consider, for an extended example for this lesson, what happens in a court of law. And consider the proposition in a criminal law case, Joni Felon is guilty of first-degree murder. This is an example of a proposition because the prosecution as well as the defense are going to put together an extended argument, making multiple claims and presenting multiple sub-arguments in order to support or oppose this proposition. So how do we decide what the responsibilities of the arguers are? In this case, what are the responsibilities of the state's attorney? What are the responsibilities of Ms. Felon's defense attorney? In order to get at this, we need to bring out the theory of one Richard Whately, 1787 to 1863. Born in London, he was an English rhetorician, logician, theologian, student of the law, and at one point the Church of Ireland's Archbishop of Dublin. This was a real Renaissance man, albeit well after the Renaissance. Whately is especially important in the history of argumentation theory for the contributions he made in his book Elements of Rhetoric in 1828. What Whately was especially concerned with, not just from the standpoint of how logic operates in the law, but also how logic operates in arguments over theology or interpretations of doctrine for the church, is how can you ultimately have debates in which you can come to the best possible answer from a logical standpoint as well as from a complete procedural standpoint. And so he contributes two critical concepts: presumption and burden of proof. When we're talking about presumption, we're talking about the predisposition to favor an existing practice or belief until some good reason for changing it is offered. If you think about it, one real easy way to consider this idea is the old adage, if it ain't broke, don't fix it. And that seems to be a pretty good rule of thumb, right? Because if something is broke, you want to fix it. If something is not broken, well, why don't you just leave it alone? If something is perfectly fine and you try to fix it anyway, then you might have the old Tim Taylor from that Home Improvement sitcom issue where you take something that was perfectly okay and you risk really screwing it up big time.
All right, Dad, let her rip.
No, wait a minute. I think we should say a prayer first. Please, Lord, don't let our house blow up.
I get knocked down, but I get up again. You're never gonna keep me down. I get knocked down, but I get up again. You're never gonna keep me down. I get knocked down, but I get up again. You're never gonna keep me down. I get knocked down, but I get up again. You're never gonna keep me down.
Ground, we're looking at the ground. Yellow, see? The sun is yellow, it heats the ground. That's how they name stuff. Is that car running? Ah! Shake it off.
So, for the purposes of a debate or a larger argumentative discussion, one side is going to enjoy presumption. The way things are right now, we're going to accept that that's true until somebody proves otherwise. Sometimes this is determined by factual conditions or common sense. Sometimes presumption is something that's set up in a procedure in order to preserve our values and to prevent risks. So for instance, in a criminal trial, the presumption before we start the case at all is that Joni Felon is presumed innocent. And we do this primarily to protect Joni Felon's rights. If we presumed before the trial ever got started that Joni Felon was guilty, it would be very difficult for her to mount a defense. How many of you have ever tried to prove that you didn't do something? Hey, did you come over in the middle of the night and key my car? No, man, I was sleeping. Can you prove that you were sleeping? No. Well, when we're talking about taking away somebody's freedom, that's something that is really risky. So in our system of jurisprudence, we establish a procedural presumption. We're going to presume that Joni is innocent until she's proven guilty. And this is where the burden of proof comes in. The burden of proof is the other side's responsibility. The burden of proof obligates arguers to provide good and sufficient reasons for changing what is already accepted. So if we believe in the old adage, if it ain't broke, don't fix it, then somebody who wants to fix it needs to prove first that it's broken. Then they've justified switching away from our assumed correct position. That's called overcoming presumption. So before we go any further, I want to present a brief video courtesy of Thomson Reuters lawinfo.com that explains what legal burden of proof is all about in a criminal and a civil trial, because the difference can be really important.
The burden of proof is the duty of one party in a legal case that is required to convince the decision-maker, judge and/or jury, that their version of the facts is true. The burden of proof is carried by the prosecution in criminal trials. A criminal defendant is presumed innocent of the charges against them until they are proven guilty by the prosecution. The burden of proof is much greater in criminal trials than it is in civil trials, largely because there is much more at stake in a criminal trial, such as potential incarceration. The burden of proof in criminal trials requires that the prosecution demonstrate the defendant's guilt for each element of the crime beyond a reasonable doubt. This means the judge or jury must be convinced beyond a reasonable doubt that the defendant is guilty of each element of the crime in order to convict the defendant.
Unlike most criminal trials where the prosecution must prove the defendant committed a crime with clear and convincing evidence or beyond a reasonable doubt, civil cases have a lower standard of proof, known as preponderance of the evidence. For example, if you were sued and the plaintiff alleged you trespassed onto their property, they would only need to prove it was more likely than not that you trespassed, not that it was absolutely certain. Now, some judges have explained the standard of proof by using this football analogy. In a criminal trial, the prosecution would need to run the entire field and score a touchdown to get a guilty verdict. In civil cases, the plaintiff would only need to cross the 50-yard line.
Okay, so if we go back to our murder trial, we know that Joni Felon is presumed innocent until proven guilty beyond a reasonable doubt, 99.9% certainty. So why then is it the case that if we were to move to a civil trial where the proposition is Joni Felon is liable for wrongful death, which is essentially accusing her of the same thing, the presumption is that Joni Felon is not responsible, so the presumption favors the same protection of the defendant's rights that we have in a criminal trial, but the burden of proof is different. In this case, the plaintiff, not the prosecutor, must prove liability, not guilt, by a preponderance of the evidence, by more than 50% certainty. And the reason for this is because the importance of the outcome is significantly different. In a criminal trial, the prosecution needs to prove guilt beyond a reasonable doubt. That jury needs to be 99.9% sure. As opposed to a civil trial, where the plaintiff must prove liability by a preponderance of the evidence, only 51% sure. We actually saw an example of this historically in the murder/wrongful death of Nicole Brown Simpson back in the early 1990s that brought us the infamous O.J. Simpson not trial, but actually 2 trials. O.J. Simpson was acquitted of first-degree murder, but later on he was actually found responsible for the wrongful death. And so we got 2 very different outcomes. And the reason is because the burden of proof is different. Now, why is that burden of proof different? Because the consequences of the outcome are different. When we're talking about proving guilt of a crime, the consequence is taking away somebody's freedom, potentially for a significant period of time, and in some jurisdictions could even involve the death penalty. Whereas if we're talking about a civil trial, if someone is being sued for being liable for something they did wrong, the consequences of the outcome are generally a fine, a monetary punishment, and in some cases an injunction that you're not allowed to do something. Because those consequences are very different, we have differing burdens of proof imposed on those that want to overcome the presumption that Joni didn't do anything wrong. Okay, so those are the ideas of presumption and burden of proof. Where do we need to go from here? Well, the prosecution in a criminal trial and the defense in a criminal trial are going to each present cases, a set of interconnected arguments supporting or opposing a proposition. So in order to establish their position and ultimately convince the jury that their side should be supported, they're going to have to support that larger claim. Either Joni Felon is guilty of murder in the first degree or Joni Felon is not guilty of murder in the first degree by presenting a bunch of different arguments on important issues. So how do we decide what the responsibilities are to meet the burden of proof? This is where the concept of prima facie case comes in. Prima facie, roughly translated from the Latin, means on its face. So a prima facie case, on its face, presents good and sufficient arguments for adopting the viewpoint or action proposed by an advocate. So at first glance, once you take a look at all the arguments that have been presented in the case, you can make a pretty good judgment that, all right, unless I get something better than this is reasonably convincing that, in fact, we should adopt the proposition and we should overcome presumption. In order to do that, providing good and sufficient arguments means that the case needs to satisfactorily address all of the major issues a reasonable audience would expect to see addressed. So what does this mean? Well, let's go back to Joni Felon's case. If the prosecution can't present a prima facie case at the initial hearing that takes place before a trial ever happens, the case may be thrown out of court. If the prosecution doesn't address all of the important points that a jury would need to consider in order to decide whether or not Joni's guilty, the defense attorney can file a motion to dismiss the case. Your Honor, the prosecution has not presented a prima facie case. We don't even have enough good and sufficient reasons up front to even consider her guilt or innocence. And, if that's the case, the judge can rule, okay, the prosecution didn't fulfill their burden of proof even at the onset, so we're going to toss this case out. So establishing a prima facie case is crucial. And so in order to do that, the prosecution is going to need to deal with all of the important issues. Well, so what's an issue? Issues are the primary subject matter points of disagreement in a dispute. So it's not just a topic or a subject matter, but it's points at which those that are disagreeing with one another in the dispute are going to coalesce around. One side is going to answer the point yes, the other side is going to answer the point no. This concept has its origins in stasis theory, a particular approach to understanding argumentation that goes all the way back to classical Roman rhetoric. Cicero, the ancient Roman rhetorician, lawyer, and politician, identified what he referred to as points of stasis in this theory. In other words, the basic points on which those for and against a particular proposition are potentially going to disagree in pretty much any context. These include the point of forum. Is this the right time and place to argue these issues? Point of conjecture. Are these factually true or not? Points of definition. How do we categorize the ideas so we know how to assess them and what the standards and criteria for our decision need to be? And finally, points of quality. Questions regarding values or relative priorities, how important something is. So for instance, if we take Cicero's framework and apply it to Joni Felon's potential murder case, we can think about it in these terms. A question of forum. Does this court have jurisdiction? You may have heard, for instance, about arguments between lawyers regarding whether or not a specific case ought to be held in a state court or a federal court. Depending on the nature of the crime, different courts have to hear it, and that's important because different courts are going to have different procedures for how they deal with certain crimes. Then we've got questions of conjecture. So did Joni Felon actually kill that guy or not? This is the kind of questions where the points of evidence, the eyewitness testimony and the physical evidence from the crime scene and things like that are going to come into play. Then there's questions of definition. Does this count as first-degree murder or not? Because depending on how the crime went down, there may be certain exigent circumstances that might say, well, this isn't first-degree murder, which is the worst kind of murder. It might be something lesser, like involuntary manslaughter or self-defense, and therefore not murder at all. And then there's questions of quality. How important is it from the standpoint of justice and public safety for Joni to go to prison? So all of these kinds of questions will be answered in one way by the prosecution and in another way by the defense. Now, of all of the relevant issues that can be discussed in a controversy, the stock issues are the most important, and the stock issues are going to be definitive for how a prima facie case is put together. Stock issues refer to the issues that recipients expect to see addressed in order for the arguer to meet the burden of proof. So, in other words, if an arguer addresses each of these issues with a good argument, then it will meet the prima facie case requirements, all of the things that an audience is going to expect to see. Therefore, it's a prima facie case. It can potentially fulfill the burden of proof and overcome presumption. Now, what those stock issues happen to be in any given case is going to depend on the type of proposition. Depending on what the central claim is, there are certain types of stock issues that are going to be relevant for certain types of claims that wouldn't necessarily be relevant for other types of claims. Let's go back to Joni Felon's case to illustrate. So if the prosecution wants to establish a prima facie case of Joni Felon's guilt in first-degree murder, there's going to be some things that this case is going to need to address. For instance, a guilty act. Was there, in fact, a wrongful death? One way that's very tricky for a prosecutor to prove a defendant is guilty of murder, for instance, is if there's actually no dead body. If you can't prove that there was a wrongful death in the first place, you could be in big trouble. Then there's mens rea, or guilty mind, otherwise known as intent. Did Joni know she was doing wrong, and did she intend to do the act that she did? For instance, Joni may have killed the guy, but if Joni was legally insane, other words, did not know the distinction between right and wrong, could not make a good call herself as to whether or not she was doing something wrong, then she may not be guilty of murder. Then there's means. Was Joni actually capable of killing the guy? Did she have access to the murder weapon that was used? Did she have the physical strength, agility, and prowess to be able to commit this kind of act? Because if she couldn't, then she can't be guilty. And opportunity. Could she be at the right place at the right time? If there's evidence that links her to the scene of the crime at the time that the crime took place, then the prosecution can meet this burden. If, however, the defense can establish that no, Joni actually was someplace else when the murder went down and there were a whole bunch of people who saw her there, well, she really didn't have opportunity to commit the crime. So, if a prosecutor who wants to convict Joni of murder can successfully prove that there was a guilty act, that Joni had mens rea or intent and guilty mind, and that Joni had the means and the opportunity to commit the crime, then you've got a prima facie case. And we can go on to trial and we can continue to examine these issues on the merits. If the prosecutor can't establish these things up front in the preliminary hearing, the defendant can do that motion I told you about earlier and have the case thrown out because it's not a prima facie case. If we think about the kinds of claims that are available for us to consider, different sorts of stock issues are going to apply. So if we're arguing a fact of claim, for instance, then the kind of issues that we're dealing with is whether or not a particular condition or relationship is true. And so there's going to be certain standards that the arguer is going to need to meet in order to overcome presumption that something is false, in order to prove that it's true. Now, in a proposition of value, the central question being debated is whether or not something is worthwhile or meritorious and whether it advances certain desirable goals. So in this kind of discussion or debate, the stock issues are going to involve what are the most important values? What is the value hierarchy? Which values are more important than other values? And then how do those values attach to whatever the subject matter is that's under dispute? And then there's policy claims that advocate courses of action, and the primary question being addressed in those debates is whether or not we should do something. We should engage in that course of action or not. And so for policy debates or discussions, there's yet an entirely different set of stock issues. Whether there's a problem, whether we know what causes the problem, will the course of action solve the problem, and do the benefits of doing that action outweigh any possible costs or disadvantages? A subsequent video lesson in this series will get into the stock issues of different kinds of propositions and claims at a future date. In order to sum up this lesson, what are the most important ideas you need to pull out? First of all, the dialectical perspective involves concern over the procedural responsibilities for useful argument. The dialectical perspective is most interested in have all of the relevant issues that we need to discuss in order to make a sound, prudent judgment. Have they all been discussed? Have they been tested against one another? And so do we have a procedure that is fair and complete and comprehensive in order to do that? And so in any dispute, arguers are going to have different responsibilities depending on their relationship to the status quo or the way things are right now. Those that want to advocate for a change in the status quo have a burden of proof to overcome presumption. Presumption is that basic standpoint that we take as a default position before the debate gets started. If it ain't broke, don't fix it. She's presumed innocent until proven guilty. And so if the advocate for change does not present a prima facie case addressing all of the stock issues, then the burden of proof has not been fulfilled. The side that enjoys presumption will prevail in the discussion, and we keep things the way they are right now. However, if the advocate does present a prima facie case, then we have to dig into the argument further to see whether or not the advocate for change will ultimately win the day, or whether the advocates for maintaining the status quo are going to be able to provide superior counter-arguments. That, too, is a lesson for another day. And so finally, the stock issues for any dispute, those issues that must be addressed in order for the audience to make a sound decision, are going to depend on the proposition. Different types of claims are going to require different types of questions to be answered and different types of decisions to be made. So those different types of decisions will involve different types of stock issues. Okay. So if you want more information about how these disputes play out in argument, you may want to check out an upcoming video lesson on the nature of claims and propositions, where we get into how fact, value, and policy claims are understood in more detail. Otherwise, if you've got any questions or concerns about the concepts in this video, don't hesitate at all to reach out and let me know. Otherwise, I'll see you next time.